Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back with the Truth Attack. Okay, so we are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the Yes, yes. Okay, okay. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. And yes, that's right, folks. We're back. We're back with the Truth Attack. Let's just get right into this show because there's a lot I want to try and cover tonight. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating. So, if you enjoy the information, the shows, the lectures, the discussions, the revelations, the guests and hosts on the other shows on the network, we sure would appreciate it if you could find your way over to the LibertyWorksRadioNetwork.com website and get signed up as a monthly subscribing member, even if it's as little as $15, $20 a month. Every membership helps, and we do need your support to keep the network operating. And if you want to get fully informed on my favorite subject on this Truth Attack Hour, Thursday evenings at 6 o'clock, you find your way over to taxfreedom.com there, start reading and get educated on the maladministration of the federal income tax by the IRS, the DOJ, and the lower federal court judges for the last 50 years. It's all been exposed by the Supreme Court in a recent ruling a year and a half ago, actually 2 years at this point, in Moore at Uxbridge, United States, where the Supreme Court declared the income tax is not a direct tax. It's an indirect tax, the court says, and it further says all direct taxes, which is how the IRS, the DOJ, and the lower courts have been enforcing the income tax. They say all direct taxes have to be apportioned to the several states for payment. They're not allowed to come to you for the payment of a direct tax. It violates the Constitution. And the Supreme Court says that's still in place. That prohibition, that limitation is still in place, despite the adoption of the 16th Amendment, which changed nothing, which the IRS, the DOJ, and the lower courts have, of course, all fraudulently used to enslave the American people to a direct tax that's applied to everything you do, without regard to the fact that you're not actually engaged in any activities or transactions subject to some indirect tax in the form of an impost on foreign imports or foreign persons or in foreign places, a duty on exported goods, or an excise on commodities, licenses, or corporations. That's why they've had to lie to you about it being the 16th Amendment that made you responsible for the tax, because you can't get there under Article 1. It doesn't tax citizens or their activities in the 50 states. It only taxes imports, exports, foreigners in foreign places, commodities like alcohol, tobacco, firearms, licenses to sell things like those commodities, and the corporate privilege, where everything earned by the corporate person is earned by virtue of the privilege of incorporation enjoyed by that person. However, citizens, as a person, do not earn money as a function of any federally or state-granted privilege. They earn money as a function of a right to live, to eat, to work. Remember the right to work? Oh, they don't. They think they can tax you on everything you do. That makes you a slave, not a sovereign citizen who is represented by the representative Congress that we have. So, it's all there. TaxFreedom.com explains it all. If you know anyone that needs help answering IRS correspondence, IRSZoom.com. Or answering the DOJ in court, IRSZoom.com. It's all there, and we have the information and the documents that can help every single person in the country, regardless of what stage of the tax collection system they're engaged with, whether it be the IRS, the tax court, the DOJ, criminal charges, or in any court arguing the case now. It's not too late to argue the lack of subject matter jurisdiction to enforce the direct tax that the IRS assessed, that the DOJ will argue if pressed, and that the lower courts will wrongfully hold up a precedent contradicting the Supreme Court if compelled to. That almost forces the Supreme Court to overturn any conviction or judgment rendered by the court if the jury doesn't get it. Which of the parties of the court should be shown this evidence? So, there you go. Things are developing, and I'm going to read some more tonight, I think, from another Supreme Court petition that we're sending to the court in the next couple of weeks. But let's talk a little bit about the news first, right? I guess we've got the war still rolling on. There's bad news and good news. Of course, bad news is that Israel appears to have attacked the oil and gas infrastructure facilities on Karg Island. I said last week that Trump was trying to avoid that so that there could be some ability of a new civilian government to economically recover and have those revenues available to help with setting up and running a new government. But the good news is Israel has agreed not to do any more of that. So we'll see. The markets all took a shock on Jay Powell announcing that he's not going to leave until the lawsuit is settled, which is bad news because, of course, that means you won't get a friendly chairman in there that's liable to lower interest rates for some time. So we'll have to see how that plays out because Jeanine Pirro, the district D.C. Attorney General for the government, says she's appealing the dismissal of the warrants by Boasberg, who dismissed the warrants against Powell and the Federal Reserve Bank to produce the financial documents that might help to explain where the missing $1 billion went, which is what the investigation is about. It's allegedly a criminal investigation into funds mismanagement where there's over $1 billion in the project that nobody seems to be able to explain. Surprise! I'm not sure Jay Powell's actually responsible for that, but as the head of the Fed, he's the named party. So he's there. She wants the documents. They won't give it up. The lower court says, no, you can't do this because it's politically motivated. Jeanine Pirro says it's not politically motivated. It's motivated by a missing $1 billion and the American people's right to know where the money went. So she's not backing down, and that's going to mean Powell stays in unless Trump steps in and directs Jeanine Powell either to drop it or pushes Powell to get out, which I'm not sure he can be effective with either push. Maybe he can direct the Attorney General to drop the suit to get Powell out. I don't know if she would do that or not. She's a pretty, she knows what she's doing, and she sticks to her guns. So there you have it. And of course, the attacks in Iran have just been decimating any military element that comes out, right down to guardsmen, Republican guardsmen hiding under bridges. Iranian people are reporting where Republican elements, where Republican Guard and Iranian military elements are hiding from U.S. and Israeli airstrikes. The Iranian people are helping Israeli intelligence, which passes the information to the U.S., and those people are being wiped out. So the A team, as they put it in Iran, was wiped out on day one. The B team has been wiped out. And now I understand the people who are leading are starting to defect or are running and hiding and won't come out because when they do, they get killed. Now, At the same time, the regime has been cracking down where possible on protesters. Of course, you'd have to imagine their ability to crack down is minimized when the troops are being killed by airstrikes that are called in by the Iranian people contacting Israeli intelligence. I'm not sure through what mechanism that's being done, but they've set something up, and of course, that's what you want to do when you have a population that supports the elimination of the regime that's been controlling them and oppressing them for 47 years. And again, when the Democrats claim Trump started the war, no, 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 no. He's ending it. Iran has been waging war on Islamic regimes, the radical Islamic elements have been waging war on the United States for 49 years. And if you don't remember 9/11 in New York, which apparently they don't because they elected a radical Islamic Muslim as mayor. I don't know how stupid you can get, but New York is testing the limits, aren't they? Yeah, they sure are. And tomorrow is the Iranian New Year, where the population normally comes out to celebrate. And they've been told by the remnants of the regime not to come out tomorrow. And I'm thinking, hey, New Year couldn't be a better date to pick to toss the old government out and start a new government with the new year. So tomorrow, we'll have to see if the Iranian population stays inside like they've been told to do, or if they come out to celebrate or protest, and if the current remnants of the regime are able to quash or prevent that celebration or protests, and the extent that it may go to in celebrating the fall of the old regime and its replacement on New Year's. So we'll have to see. If that were to happen, I think it would accelerate the recovery, economic recovery all over the planet, which looks to be impacting the rest of the world more than the US because, of course, we have the ability to be energy independent and they do not. They are subject to supply issues, which we will have, admittedly, as long as the Straits of Hormuz aren't navigable. But they're working on that, and I think I saw earlier they have a League of Nations, France, Great Britain, several others that have committed to helping the U.S. manage and escort ships through the Straits of Hormuz so that they can get oil moving again, and that would, of course, settle the markets and bring the price of oil back down again, because nobody likes to see oil up at $90 to $100 a barrel, knowing that, we've seen it before, it's going to ultimately hit the price of gas and drive it even higher than the 50 cents it jumped on the outset of the war. But again, hopefully, that situation can begin to be ameliorated by what happens possibly tomorrow or militarily over the next few days if it doesn't happen tomorrow. Okay, in New York, Governor Hochul is begging rich New Yorkers who have left to come back because she says their tax base has shrunk. Oh, there's a surprise. Oh, gosh, who could have thought that raising taxes and letting crime run rampant in New York City would have driven wealthy people and businesses out of it? Who would have thought? Who would have thought letting crime run rampant and people sleep on the doorstep? Who would have thought that not addressing crime would be bad for business and drive wealthy people away, trying to tax them? Gee, gosh, that was completely impossible to predict, wasn't it? I mean, just who would have thought? So now she's begging them to come back to what? New York City and commie Mamdani? You gotta be kidding me! He wants to raise property taxes 10% and tax the wealthy. Yeah, right, I'm coming back to that. Sure thing. We'll be back in 5. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and let's just get right back into this. I think I got two more quick current events items I want to go through, and then we'll get back into, or we'll begin to get into the new petition to the Supreme Court that we've come up with. All right, so we got the NCAA tournament starting up. It's busy all day today, tomorrow, Saturday, and Sunday. This weekend is one of the best weekends of the year, of course, for good basketball because you got 64 teams, the best in the NCAA after 5 months of battling it out. And in the NCAA tournament, if you pay any attention at all, you usually get a number of good games. And today it started right out with a number 12 seed High Point defeating number 5 Wisconsin by 1 point, 83-82. I didn't see it, but I'll bet the YouTube highlights are on, and I'll bet they're good. High Point might be this year's Cinderella. We'll have to see what happens tomorrow in the other half of the brackets. And at the same time as the NCAA basketball tournament, you have the NCAA wrestling tournament, which I know most people don't care about or watch, and I understand wrestling is like baseball. It's incredibly hard to watch a whole season of tournaments with mostly mediocre wrestlers. But again, when you get to the NCAA wrestling tournament, you've got the best wrestlers in the country, all in one tournament. And it generally has some sensational wrestling. So you might want to check that out too. And the last thing I want to mention is what's happening in Virginia. I don't know if the rest of the country knows what's going on there, but the current governor, Abigail Spanberger, is an ex-CIA officer, and she ran claiming to be a moderate. And Virginia's been a purple state. It goes back and forth. It voted for Trump, but it also votes blue. Republicans, it said, ran a less than spectacular candidate. Spanberger won with Democratic majority in the House and the Senate in Virginia, so they own the government, and now they've come forward with all sorts of bills, just far left radical nonsense to socialize and communize Virginia. They're going after guns, they're raising taxes, they're installing a whole bunch of new taxes, and despite the fact that just a few years ago, Virginia went under a constitutional redistricting, and for the past several years, it's been held up as one of the fairest district divided states in the country. It's got 11 seats in the Congress, and the districts are split 6-5. Now, the Democrats have strong bases in the Northern Virginia Fairfax County area and in the Richmond and Norfolk areas. But what the Democrats have done is write a bill to again redistrict Virginia. And they did it in violation of the timelines for holding a special election, but they put a constitutional amendment up to have an election to approve a new districting plan put out by the Democrats that runs, I believe, 7 of the new districts through the heavily blue Fairfax County in Northern Virginia, ultimately resulting in what the Democrats believe will be a redistricting plan that results in a 10-1 Democrat majority. By running all the districts through Virginia, they can use that population density to overcome the Republican votes in the less populated rural areas of Virginia, which are all solid red. So Virginia is blue based on the urban populations around Washington, D.C. and Fairfax and Arlington counties, as well as the others, and in Richmond and Norfolk, where you have heavy black populations that for some reason vote Democrat. Now, what happens if this redistricting plan is allowed to go through, and in the midterm elections, the Democrats do, in fact, win 10 seats to the Republicans' 1? Well, what that will do, and most people don't understand, this isn't really about the Democrats seizing absolute power in Virginia forever, because they've posted it as a temporary redistricting that will go back to the districts that exist now in I forget if it's 28 or 30, but it's going to go back to the way it is now. So if they are successful in getting this constitutional amendment through in Virginia, they're being very, very dirty and dishonest. They're running ads and memes saying Trump supports fair votes, restoring fairness to elections in Virginia. Of course, if you vote yes to restore fairness, which is how the ballot is phrased, that means they're going to get to 10-1. It's absolutely unfair. There's nothing fair at all about it. Obviously, some Democrat wrote the measure to deceive people about what it is at the polling places when they vote and see it for the first time, which is the situation with most constitutional amendments. People don't pay attention until they get in the polling place. Oh, fairness, sure, I'm for that. It's for absolute unfairness. It destroys fairness. It takes away 4 Republican seats and gives it to the Democrats. Now, guess what that does in the Congress, the U.S. Congress? It changes the balance of power from Republican to Democrat. The Republicans only have like a 2-seat majority in Congress. If you take 4 seats away and give it to the Democrats, they will own the midterm elections, they will own the House, and they will spend the next 2 years trying to impeach Donald Trump and opposing every single thing he does to help Americans, including deporting criminals, drug dealers, cartel members, and other criminal illegal aliens that are murdering and raping American women and children. Get them out! How the hell can the Democrats support that? Not a single Democrat stood for America when Trump asked them to stand if they believed their primary duty as a congressman was to keep the American people safe. Not one single, John Fetterman stood up. Other than Fetterman, not one single Democrat stood up. Today, Fetterman was on TV raving about how the Democratic Party is going mad with this Trump derangement syndrome that is obsessed with and seems to be the only plank in any of their policy positions. So, what the Democrats are trying to do is steal the midterm elections with a temporary redistricting plan in Virginia that will steal the 4 seats just in Virginia alone. That means the Democrats can steal the midterm elections just on the Virginia results alone. So everyone who hears this, if you know anyone in Virginia, you need to tell them it's important. Get out and vote no on the April 21st constitutional amendment ballot. It's the only question on the ballot. Should we let the Democrats take over Virginia for 5 years so that we can impeach Trump for the next 2? So that's what's really going on, and it's incredibly dangerous because in Virginia, they have the majority. They're putting up the billboards. Vote to restore fairness in our elections. It's really help us throw Donald Trump out of office because he's exposing us as idiots who don't work for America. We work for ourselves. That's the Democrat Party motto, isn't it? We work for the party. To hell with America. Let the aliens murder them and overwhelm social services. Hell, let's get as many of them to vote because they're welfare dependent. And that's why they brought them in. That's why they sent them where they did, is to ultimately sign them up to vote, to prevent Democrats from losing seats in the Congress and from losing votes in the Electoral College. Which effectively gives representation to foreigners and takes it away from citizens. and prevent states like California, Massachusetts, and Illinois that have an exodus of citizens. It prevents them from losing the seats they would lose because the illegal aliens are being counted in the census, which was also never the intent of the founding fathers. They knew that there would be a small alien presence in America and that it could be counted for the census, but they never anticipated 30 million illegal aliens flooding the country and being allowed to vote in order to steal representation away from the American people and give it to one political party using the illegal aliens to prevent themselves from losing votes. So what happens in Virginia pretty much has the potential to dictate what happens over the next 2 years. So we need to get out and vote no on April 21st in Virginia. And as I said, anyone who puts stuff up on YouTube or on the net needs to help us get this message out to everyone in Virginia. Because in the midterms, historically here for the past 10 years, Republicans have been a little light in their eagerness to go out and vote. If Donald Trump isn't on the ticket, Republicans, they don't get motivated for the regular politicians. I understand that. But this is important. Trump is on the ticket. Trump is on the ticket in Virginia. This is Trump on the ticket. This special election is all about impeaching Trump, taking control of the Congress with 4 seats that swap. Everything else can go exactly as it is. They don't have to take another seat anywhere in the country. They can do it all with redistricting in Virginia. Steal the election again. So that's where we're at. Okay, what do we do here? We got 3 minutes left till we come up on the next break. I guess we ought to just go ahead and jump into it. I've been working on another version of the petition, and we've come up with some additional arguments, reasons for granting the petition. Now, the issues that we're raising are the same issues that we've raised in the other petitions, which are 1, income taxes are indirect taxes under Article 1, Section 8, Clause 1, which means they are of the form of impost, duty, or excise. No such thing as an income tax. It's an impost, duty, or excise where income is the yardstick that measures the amount of the tax owed on the taxable activity or transaction subject to the impost on foreign, the duty on export, or the excise on commodities, licenses, or corporations. And the issue is, as it was declared in Moore, the same as it was declared income taxes are indirect taxes. The court also declared that all direct taxes must be apportioned to the several states in proportion to the census. They held that the limitations on direct taxation are still in place. And of course, all of the circuit courts for 50 years have been telling you, oh no, those limitations are gone. They were overruled by the 16th Amendment. They've been lying. Court never said that. Supreme Court never said that. The circuit courts intentionally reversed the Supreme Court decisions of Brushaber, Stanton v. Baltic Mining, and Stewart Machine in 1937 to start imposing, collecting, and enforcing a non-apportioned direct tax on all earnings of all citizens under the guise and pretense of taxing income under the 16th Amendment without limitation. And it was all fraud. And since direct taxes have to be apportioned and there is no direct tax on income, that means the federal courts lack subject matter jurisdiction to enforce any claim for tax based on that claim that you owe it because it's direct and not connected to any impost, duty, or excise taxable activity. Okay, we'll get into the reasons for granting the petition when we come back in 5. This is Thomas Freed on the Liberty Works Radio Network. We'll be back in 5 with more on Moore. Okay, this is Thomas Freed on the Liberty Works Radio Network. Let's just get right back into this, shall we? We are going over the new elements of a petition to the Supreme Court addressing this problem that's been exposed by the Supreme Court ruling and more, that exposes the fact that the lower courts have not been enforcing a constitutional version of the income tax for 50 years. So let's get into this. Reasons for granting the petition. 1. Moore abrogated the circuit court's holdings, creating a direct conflict in the circuit court's precedents that the full court declined to resolve en banc. A. Moore and the circuit court state and hold to irreconcilable constitutional propositions. The U.S. Circuit Court of Appeals have all held that the 16th Amendment authorizes a non-apportioned direct tax on United States citizens throughout the nation. But Moore held income taxes are indirect taxes under Article 1, Section 8. The Moore Court stated in its syllabus, A. Article 1 of the Constitution affords Congress broad power to lay and collect taxes. That power includes direct taxes, those imposed on persons or property, and indirect taxes, those imposed on activities and or transactions. Direct taxes must be apportioned among the states according to each state's population, while indirect taxes are permitted without apportionment, but must be uniform throughout the United States. Taxes on income are indirect taxes, and the 16th Amendment confirms that taxes on income need not be apportioned. Yeah, that's true, but they cannot be direct. They have to have some nexus with a transaction or activity like import-export subject to impost duty or excise, and there is none. Under Article 1, Section 8, that only taxes imports, foreign persons, and in foreign places. Doesn't tax people in the 50 states unless they're importing goods. Duties tax exported goods. That's not labor of the citizens in the 50 states. And excises tax privileges and commodities and licenses. So where is the right to work taxed under Article 1, Section 8? It isn't. And that's the fraud. They know there's no Article 1, Section 8 tax that reaches your labor. That's why they had to lie to you about it being the 16th Amendment. And they have lied to you for over 70 years. Moore's reasoning traces to Brushaber and Stanton v. Baltic Mining in 1916. Which established that the 16th Amendment prevented the income tax from being taken out of the class of indirect taxation to which it inherently belonged. And in Stanton, the court also declared that the amendment conferred no new power of taxation. The circuit courts have inverted these holdings by reading Brushaber as authorizing an unlimited, unavoidable, direct, not apportioned to tax on all earnings. The circuit court decisions, direct tax, and more, it's an indirect tax, cannot be reconciled. Only this court's intervention can resolve the dire constitutional conflict. Notably, 3 justices wrote separately in Moore to signal concern about the broader implications of income tax doctrine. Justice Thomas, joined by Justice Gorsuch, dissented and would have held that the 16th Amendment requires realization as a constitutional prerequisite to tax, a position directly in tension with the prosecution for evading a tax whose constitutional basis was never established on the record. Justice Barrett, joined by Justice Alito, concurred in the judgment but wrote separately to emphasize that the majority's holding is expressly narrow and leaves open foundational questions about the constitutional definition of income and the scope of Congress's taxing power. These concurrences signal that at least 4 members of the current court recognize that Moore did not resolve and deliberately left open the constitutional questions this case presents. Petitioner respectfully submits that those open questions are squarely presented here. What are you doing? Where'd you go? Okay, excuse me. Okay, B. The en banc denial confirms the circuit will not self-correct. Petitioner presented the more indirect, direct taxation conflict and question to the full Fourth Circuit in the en banc petition. Not a single active judge requested consideration of the question. Appendix B. The Fourth Circuit has institutionally declined to identify or address whether or not previous precedential holdings of a direct non-apportioned tax survive Moore in the Fourth Circuit. Every 7201 prosecution brought in the circuit under the direct tax theory now rests on a constitutionally erroneous foundation that the court has declined to acknowledge or correct to be in accord with Moore and the doctrine of stare decisis. As the 10th Circuit's precedent of United States v. Collins, hereinafter Collins, was invoked and cited in this case in the government's sentencing memorandum, it will be used hereinafter to refer collectively to all of the U.S. Circuit Courts of Appeals decisions, Appendix E, holding that the federal personal income tax is a non-apportioned direct tax under the 16th Amendment, which of course is erroneous under Moore. The 10th Circuit's 3231 analysis is constitutionally insufficient. The trial court effectively held that Section 3231 alone supplies jurisdiction, regardless of the constitutional taxing theory underlying the prosecution. As this court has held, as regards all courts of the United States inferior to this tribunal, 2 things are necessary to create jurisdiction. The Constitution must have given the court the capacity to take it, and an act of Congress must have supplied it. Finley v. United States, 1989. Federal courts are courts of limited jurisdiction. They possess only power authorized by Constitution and statute, which is not to be expanded by judicial decree. It is presumed that a cause lies outside this limited jurisdiction, and the burden of establishing the contrary rests upon the party asserting jurisdiction. That's Kokanen v. Guardian Life, 1994. Section 3231 is statutory. It cannot confer subject matter jurisdiction over a taxing power that the Constitution does not authorize. The Collins decision and all the other circuit courts' decisions specifically invoked the 16th Amendment, not Section 3231, as the constitutional authority for the income tax to be applied to individuals as a non-apportioned, unlimited, unavoidable direct tax on all income. The government premised this prosecution on the direct tax that was assessed by the IRS, simply based on the defendant's earning money, and which assessment was not based on his conducting a federally taxable activity or transaction that was subject to indirect federal taxation by impost, duty, or excise, as neither were factually identified in the record as foundational to the claim that tax was owed by the defendant. The factual record in the case reflects this truth. D. The Cromar citation underscores the need for this court's review. The 10th Circuit has already cited United States v. Cromar, citing Collins as precedent for rejecting Moore-based challenges. See 10th Circuit Court Order and Judgment in United States v. Walcott. At least 2 unpublished circuit decisions now reject Moore-based challenges to criminal tax jurisdiction without engaging the more direct tax conflict. This pattern is foreclosing the constitutional question for all future criminal tax defendants in the circuit courts. Petitioner requests this court consider consolidating this petition with Cromar and Walcott, or holding it pending the resolution of any related cases. 2. The 10th Circuit's jurisdictional analysis is constitutionally deficient and conflicts with this court's decisions. A. The nature of the tax is an essential constitutional element of Section 7201. IRC Section 7201 requires as its first element a quote-unquote tax imposed by this title, Spies v. United States, 1943. Whether a tax was legitimately constitutionally imposed is a threshold constitutional question. A criminal conviction for evading a tax mischaracterized as a direct unapportioned 16th Amendment tax, when the Constitution authorizes only an indirect Article I tax, rests on a legally deficient foundation, regardless of Section 3231's general grant of criminal jurisdiction. Quote, whether the tax is to be classified as an excise is in truth not of critical importance. If not that, it is an impost. Citing Pollock v. Farmers Loan, Pacific Insurance Company v. Sobel, or a duty, citing VZ Bank v. Fenno, Pollock v. Farmers Loan and Trust, Knowlton v. Moore. A capitation or other direct tax, it certainly is not. Stewart Machine Company v. Collector, 1937. The indirect tax character has substantive consequences for 7201 prosecutions. Under the correct constitutional framework, income is the measure of an indirect tax of the form impost, duty, or excise. Income is not the subject of taxation. The subject of taxation is the indirect taxation of the specific taxable activity or transactions conducted that were subject to federal taxation by impost, duty, or excise. This court has held, quote, duties and imposts are terms commonly applied to levies made by governments on the importation or exportation of commodities. Excises are taxes laid upon the manufacture, sale, or consumption of commodities, upon licenses to pursue certain occupations, and upon corporate privileges. It is the privilege which is the subject of the tax. Flint v. Stone Tracy, 1911. And Congress adopted the income as the measure of the tax to be imposed with respect to the doing of business in corporate form, measuring the taxation by the total income. Stratton's Independence Limited v. Halbert, 1913. A prosecution for evading an indirect tax must identify the specific activity or transaction to which the indirect tax, as impost, duty, or excise, attaches. The Collins and other circuit court decisions direct tax theory that all individual income is directly taxable without identifying any specific transaction or federally taxable activity is constitutionally wrong. The government never identified the specific taxable activity or transactions conducted, allegedly giving rise to the tax obligation that the petitioner allegedly evaded. The motion to void judgment that was summarily denied by the district court would have compelled that required full disclosure of the subject matter jurisdiction of the court taken by compelling the disclosure of the underlying constitutional foundation for the claim that a specific tax was owed. Okay, I hear the end of the show coming up. We're going to continue with this next week. This is Thomas Freed on the Liberty Works Radio Network. Keep listening, get educated, taxfreedom.com, get help at irszoom.com. Thank you. Yep.